Hi, my name is Evan Dunn, and today I will be doing my critical assignment on the legal aspects of kinesiology, um, with my facility being occupational therapy. So, with my facility being occupational therapy, the reason behind this choice was the desire to pursue a career in occupational therapy and getting my specialization in both pediatrics as well as geriatrics. Um, Pediatrics has always been a desire, whether it be occupational therapy or any of the other therapies, due to just being surrounded by children all of my life, being the older child and having the responsibility to take care of others that are younger than me has always been important to me. Geriatrics, I have grandparents that are getting older, and so being able to provide them the necessary tools to ensure that they are maintaining a sense of independence is what is important to me. The pediatric specialization would provide treatment for children, allowing them to reach developmental milestones, as well as fulfilling everyday activities while developing skills that are necessary in education. Geriatrics is a specialization that would be a form of rehabilitation therapy, which would also help perform everyday tasks and make them easier and safer for them to do. Also being able to address the cognitive function that tends to decline at this age. So those are the overall reasons and background for this choice in this facility. So with there being many legal concerns when it comes to occupational therapy and their facilities, knowing the different risk managements is very important. So the three different risk managements that will be discussed is personal injury, negligence, and malpractice. This first case is Banzuli versus Lieberman Center for Health and Rehab. This was a case where a plaintiff was undergoing treatment from a occupational therapy student, with the licensed occupational therapist supervising the student at this occupational therapy clinic. The student was supervised during the treatment, causing for there to be an appeal on this motion. In order to prevent this lawsuit from happening, verifying that licensed personnel are providing treatment will ensure that personal injuries are not occurring. Implementing injury prevention activities would ensure the inability to be injured at these occupational therapy facilities. Manual therapy is also a therapy that can be used to improve safety, with handheld tools such as thumb splints, mobilization wedges, and devices to aid soft tissue mobilization. So that is the personal injury case. The next case is negligence. This negligence case was Paul versus Jamaica Hospital Center. This was a case where the plaintiff was being treated for a gunshot wound in the right arm, which caused a loss of sensation. The allegation was that there was an occupational therapist that was treating the plaintiff during one of the plaintiff's sessions, and the therapist was putting cold and hot compresses on the wound, on the injury at hand, and kept it on for a duration of time for longer than needed to be, over 8 weeks. Over time, there was a blister that was forming, causing for it to burst after being turned away from the emergency room. Prevention strategies would be to enforce the principle of non-malice, which would ensure that there is no harm or injury or wrongdoing that is being done toward the recipient of care. This would also ensure that therapists are know that the potential risks that may arise when providing care that is not going to be beneficial for the patient. The next case is a malpractice case by a case Bryson versus Genesis Regional Medical Center, which highlights a permanent injury of the brachial plexus at this regional medical center. The plaintiff was requesting occupational therapy treatments and was offered it, and it was never received, causing for the injury to not resolve itself. The occupational therapist, the therapy was not a need according to the professionals. A strategy that can be used is the implementation of the principle of beneficence, which includes all forms of action intended to benefit other persons, which will prevent harm, promote good, as well as protecting and defending the rights of the individuals involved. So being able to make sure that the client is getting the care that is needed and not having to go without care in order to make sure that they're feeling better and they're not dealing with these ailments for the rest of their natural born lives. So now we're going to go into the employment laws. These are lawsuits that can occur when there is wrongful treatment of the employees that are working at these occupational therapy facilities. So the three employment laws that will be discussed are wrongful termination, discrimination, as well as disability discrimination. This first case is from the United States District Court for the Northern District of Texas, Dallas Division, Nichols versus Health South Corps. The plaintiff was suing the defendant for being terminated from employment after reporting a violation of the law that she refused to leave several patients unattended to perform a test on a walk-in patient. There is a Texas common law that states that there is no applicable exception for employment at will doctrine for private whistleblowers. So therefore, the court would then grant the corporation's motion in the summary judgment. A way to prevent this wrongful termination lawsuit is to implement employee termination policies, which would hire the right people, document the employment relationship from the very start, as well as the many different steps that are needed in a policy for employee termination. The next lawsuit is discrimination, but the case is United States District Court for the District of South Carolina, Florence Division, Dodson versus Conway Hospital Incorporated. This was a case where there was, where the plaintiff was looking to discuss her work hours and where she would be located to work. There was discrimination on her work capabilities and not being given her work site when she needed it. The defendant had prepared a statement discussing that there was an opening for a new position that was offered to the plaintiff that she then denied due to her being disinclined to work 40-hour weeks, 5 days a week. This was communicated to the employer at the time. Therefore, the defendant's motion for summary judgment was granted and the case was dismissed as a whole. A way to prevent these discrimination lawsuits is to enforce anti-discrimination laws and having open dialogue on this topic, which provides protection for the workers, making sure that they have a voice to be heard and that being treated unfairly due to their race, gender, and national origin is unacceptable. The final employment law that will be discussed is the disability discrimination. This is a case from the United States Court of Appeals for the Seventh Circuit, KIN versus Kijazi. This was a case where the plaintiff applied for disability multiple times after suffering from spinal disc problems, chronic back pain, leg muscle weakness, and numbness, arthritis, migraines, and psoriasis. The plaintiff was working as an occupational therapist assistant at the time, which would conflict with the ailments that have been discussed. The filing for disability was denied multiple times due to there being evidence that the plaintiff was able to perform these jobs. Therefore, due to there being no medical opinion evidence indicating proof of disability, the judge was affirmed. Prevention strategies that could ensure that these lawsuits do not occur for disability discrimination is to develop allies that would support in employing disabled people and providing them the insurance benefits that are needed, developing a disability network, which would give the support and find the necessary benefits that would assist with furthering their work. Reinforcing the Americans with Disabilities Act would also ensure the workers with disabilities are treated and supported in a positive way, as well as protecting those workers from discriminatory actions. This is the application and faith integration. Sports law is very important and it can make or break your facility just with the different laws that are prevalent with the employment laws as well as the risk management when it comes to discrimination and malpractice and negligence and all of the different risks and laws that can cause for there to be a sense of backlash that can come against the therapy facility. And knowing the different lawsuits that can be made and instilling preventative strategies could eliminate the potential injuries and other risks that may arise. So those were the few things that I took away from this course. If I became a manager or director of a facility for occupational therapy, I would more so look out for the negligence and malpractice lawsuits and instill those preventative action strategies to ensure that it does not occur. So a few things that I would assist in my legal management would be employee termination policies, anti-discrimination laws, and different principles that are integral in providing the best care in occupational therapy. There are many scriptures that just discuss the way we can apply God's word in our everyday lives as well as in the workplace, which can be tied to facilities in this case. Ephesians 6:9 says, Masters, do the same to them and stop your threatening, knowing that he who is both their master and yours in heaven, and that there is no partiality with him. Ensuring that those in the managerial positions are aligning themselves lawfully to prevent individuals from being treated unfairly. Deuteronomy 16:18 says, You shall appoint judges and officers in all your towns that the Lord your God is giving you, according to your tribes, and they shall judge the people with righteous judgment. Being able to provide employees with the best care and meet the needs of their employees is also what God desires for us. As stated in Psalm 34:10, the young lions suffer want and hunger, but those who seek the Lord lack no good thing. So those are ways to take that into occupational therapy facilities or any facilities that are chosen. I believe that with using God's word, there's no real way to face legal issues because you're providing care to the whole person rather than partial. God is about providing care to the whole body and not just half of a person. And so being able to meet their needs and being able to treat each other in a way that is effective and positive can ensure that lawsuits do not occur and occupational facilities continue to be in service for those who need it. These are my references, and I hope you learned something from this presentation and enjoy the rest of your day.